Hey everybody, Lauren Mulrain back with the course, Copyright Law Part 7. Now, this is the last in our initial series on copyright law. The course is designed to teach about general entertainment law issues, and those include such things as copyright and record deals and some other areas that we're going to touch on. But I wanted to start off by just doing an overview of copyright. So that's what these first 7 videos have been, just a general overview of copyright. And then starting with our next video, we'll start getting into entertainment deals, specifically record deals, deals for recorded music. But for today, we're in part 7 of our copyright discussion, and we're talking today about remedies. Remedies. A remedy is something, when you think of the word remedy, what do I use to fix a situation? What do I do when something is wrong? For example, a cold remedy. I take cold medicine to fix my cold. Well, in copyright law or in any law, remedies are granted to fix a problem or to place the person who's been injured in a place where they should have been. So in copyright law, of course, we have remedies for copyright infringement cases. So where does this all start? Well, of course, we have to first start out with having valid copyright. A person who creates a work has a valid copyright. Then they are able to prove copying by the defendant, and they must prove that the defendant's copying constitutes an improper appropriation. So those are the 3 things you need right off the bat in order to even open the door to discuss a copyright infringement case. It's difficult to show direct proof sometimes, so we end up showing circumstantial evidence or circumstantial proof, which is shown by proving access and substantial similarity. Access meaning that the party had a reasonable opportunity to copy the work, and similarity. The similarities exist between the works that are probative of copying or indicative that a copying has occurred. Now, in order to prove access, the plaintiff must show the defendant had a reasonable opportunity to view or copy the work. Often we talk about, the defendant saw, heard, or had a copy of the work. A mere speculation of access is not going to be sufficient. And generally speaking, the evidence has to be sufficient so that the trier of fact, the jury, would be able to infer a reasonable probability of access. With direct access, you need to show that the defendant either saw, heard, or had a copy of the work. Indirect access can be inferred from something we call wide dissemination. So if the work has been out in the public, maybe it's a hit on the radio, maybe it's been shown on a TV show, or some other way that you can show it's widely disseminated, we'd be able to infer access in some of those cases for copyright purposes. Access is presumed when 2 works are so strikingly similar that independent creation is not a reasonable possibility. That's important because one of the defenses for an allegation of infringement is that the work was independently created. If you can actually show independent creation, you may be able to avoid the liability for copyright infringement. Now, even striking similarity is not enough to infer access unless there is some evidence making it reasonably possible that the plaintiff's work was actually available to the infringer. There's got to be some way that you can show that connection. So once we have all that, we get to the question of remedies. How do we fix a situation? And for the most part, we'll be looking at civil remedies, right? Because if you're suing someone for infringement, it's a person suing another person or someone defending from an allegation from another person. Those are civil cases, and civil remedies apply. There are 4 basic civil remedies for copyright infringement. Number 1, injunctions. An injunction could be preliminary or permanent injunction. Number 2, impoundment and or destruction of the infringing goods. Number 3, damages. And damages we'll define a little bit later as well, but damages can be actual or statutory. And number 4, court costs and attorney's fees. So those are the 4 civil remedies. For criminal cases, which are much more rare, fine and or imprisonment can be applied to the defendant who is found to be guilty. Now, back to those civil remedies. Number 1, injunctions, right? An injunction is when a court orders someone to do something that they haven't been doing or to stop doing something they should not have been doing. Those injunctions can be preliminary or can be permanent, depending on where we are in the actual status of the dispute. The second remedy, impoundment and or destruction of infringing goods. So if we are found to have infringed someone's work, our works might be pulled off the store shelves, or they might be pulled out of the warehouse, or the bootlegging operation might be seized, and those goods could be impounded and destroyed. Number 3 in those remedies was damages. Remember we said it could be actual or statutory damages? Well, actual damages are basically just defined as the plaintiff's loss plus the defendant's gain. Actual damages, the plaintiff's loss plus the defendant's gain. Statutory damages, on the other hand, are outlined in the statute as having a specific range, and that range can be anywhere for a typical infringement, anywhere from $750 to $30,000 per infringement. There are also some parameters that go beyond that basic guideline. If we show that it was an innocent infringer, someone who really had no idea they were doing the infringement, maybe there was no notice or no reasonable expectation that this was something that was copyrighted, you can possibly have a remedy as low as $200. So instead of that $750, it could be as low as $200 per infringement. And on the other side of the scale, if it's found to be a willful infringer through their actions and their operations and such, that infringement can be as high, that remedy can be as high as $150,000 per infringement. And so you can see where some of these cases, like the Grokster case and Napster and such, where there was a high level of infringement and a number, thousands or millions of cases, you can see that the infringement dollars can easily get up well into the millions. Hold on to this idea about statutory damages for a second. Number 4 is court costs and attorney's fees. So the winning party can have court costs and attorney's fees applied to the remedy as well. Court costs and attorney's fees, the 4th one, and 3B, the statutory damages, those are only available if the party who is the plaintiff actually registered the work prior to the infringement. Of course, you have to register just to go to court anyway. But if you register after the infringement has begun, then you have forfeited your opportunity to get statutory damages or court costs and attorney's fees. As for those 4 remedies, the plaintiff can choose to get all 4, with, of course, the exception that you have to get either actual or statutory damages, not both. And you can only get statutory damages and court costs and attorney's fees in the event of registration having occurred prior to the infringement. All right, so that's our quick look at copyright remedies. Hopefully, you will not be on the wrong side of a copyright case. And if you find yourself in those waters, of course, you should get competent counsel to handle that. And of course, if you're on the other side where you believe someone has infringed upon your work, again, you should find counsel, legal counsel, who can advise you in that regard. So that's it for this episode number 7 of the course, Copyright Law Part 7, Remedies. We will see you next time.